Why the Hillary Clinton campaign can't hide 38 documents from the special counsel? Well, we know they're going to try. But before we get started, go ahead and hit that like button. Share this out so we can get this information out there. Subscribe if you're not already a subscriber. Hit that alarm bell so you know when I'm putting out new stuff. Also, check out my link tree in the description. It has a link to my Patreon where I talk about things I can't talk about here. There's also a link to my merch store where I have Let's Go Brandon t-shirts, I Will Not Comply t-shirts, so check those out. There's also a link to my mental health coaching and consultation page where if you're suffering from any type of issues, any type of mental health issues, anxiety, depression, or anything like that, I can teach you how to manage those issues. I can teach you coping skills and how to deal with those issues. All right, so let's talk about this news. While the special counsel had a strong case that the documents were not protected by attorney-client privilege, new documents strengthen it. Documents made public last week by the Federal Election Commission revealed that Hillary Clinton campaign payments to Fusion GPS to dig up dirt on Donald Trump were not treated as legal expenses. The newly released documents eviscerated the Democratic National Committee and Clinton campaign's attempt to hide behind attorney-client privilege in the special counsel's criminal case against former Clinton campaign attorney Michael Sussman. Sussman, who awaits trial in a D.C. federal court later this month on a charge that he made a false statement to former FBI General Counsel James Baker, is currently fighting to keep prosecutors from seeing 38 documents withheld from the grand jury based on claims of attorney-client privilege. In early April, special counsel John Durham's team filed a motion to compel those secret in the documents to provide them to the court to allow the judge to assess in camera whether they are properly withheld, whether they were properly withheld, In response, Sussman argued the special counsel had waited too long to force the issue and that the criminal case was the wrong firm to litigate the question. The day after the former Clinton campaign attorney filed his response opposing in-camera review of the material, his, quote, fellow Spygate hoaxers sought to join in Sussman's effort to keep the document concealed by seeking to intervene in the case. Last week, the trial court granted the flurry of motions to intervene, authorizing tech executive Rodney Jaffe, Fusion GPS, Perkins Coie, the DNC, and the Clinton campaign to file briefs opposing disclosure of the documents. I mean, they're really circling their wagons here. On Wednesday, the court will hear oral arguments on the special counsel's motion and decide whether the 38 documents must be turned over, initially to the court and then eventually to prosecutors. While Durham's team previously had a strong case that the documents were not protected by attorney-client privilege, a document dumped last week by the FEC further strengthens the prosecutor's position. A little more than a month ago, news broke that the FEC had fined the DNC and the Clinton campaign more than $100,000 related to those organizations reporting of fees paid in 2016, and I did a whole report on that. But those fees were paid to Fusion GPS for opposition research, but marked on financial disclosures as legal expenses remitted to its law firm, Perkins Coie. Until Thursday, however, the basis for the FEC's conclusion that probable cause existed that the DNC and the Clinton campaign had misreported the purpose of those disbursements remained buried in bureaucracy. So what do they have to hide, though? These are the same people that's asking us what do we have to hide, and they don't mind spying on us, but then they're gonna claim client attorney privilege when we ask to look at their records. But the now released file about the FEC investigation into the DNC and the Clinton campaign contains a bevy of material. It includes most relevantly a memorandum prepared by the FEC's Office of General Counsel and approved by the FEC. The memorandum concludes that probable cause supports a finding that both the Clinton campaign and the DNC misrepresented the purpose of the payments to Fusion GPS. While the political organizations reported the payments to Fusion GPS as, quote, legal services or, quote, legal, and compliance consulting, the FEC concluded probable cause existed that the expenses instead related to opposition research, which we already know. The memorandum, one issued related to the DNC, and the second addressing the complaint against the Clinton campaign, begin with the FEC General Counsel's office reciting the now well-known facts, beginning with the players. Perkins Coie served as General Counsel for the DNC during the 2016 election cycle, the memoranda say. Then, in April 2016, Perkins Coie hired Fusion GPS to perform, quote, a variety of research and consulting services. The memoranda then recount the evidence the FEC General Counsel reviewed, which, quote, included invoices, account statements, copies of checks, and wire transfers. The evidence, the FEC concluded, showed, quote, the DNC paid Fusion GPS $770,907.97 for opposition research, while reporting the works as, quote, legal and compliance consultant. Similarly, the FEC concluded the Clinton campaign inaccurately reported $175,000 of payments to Fusion GPS for opposition research as legal fees. That's a big no-no. If it's opposition research, you can't call it legal fees. Rather than fight the FEC's conclusion, the DNC and Clinton campaign entered settlement agreements with the agency, agreeing to pay a fine and refrain from similar violations in the future. Yeah, right. While not conceding the violations found by the FEC, the DNC and the Clinton campaign nonetheless agreed they would, quote, not further contest the commission findings, because they know it's true. I mean, if it's not true, why would you settle? Why wouldn't you fight it? But after the DNC and the Clinton campaign filed their motions to intervene in the Sussman case, the attorney for the Coolidge-Reagan Foundation, the organization that had filed the complaint against the DNC and the Clinton campaign with the FEC, dispatched a 3-page letter to the special counsel's office. The foundation's letter from its counsel, Dan Backer, summarized the key details about the FEC's recent decision, then suggested the DNC and the Clinton campaign agreement not to, quote, further contest the commission's findings should prevent them from asserting attorney-client privilege in the Sussman case. And that's exactly. So they didn't fight it with the FEC, so why now all of a sudden they said, well, no, you can't look at our stuff because of because of attorney-client privilege. Well, if that's the case, why didn't you fight it when the FEC brought these charges against you? Why didn't you fight it then? But, quote, the government should not permit HFA and the DNC to adopt conflicting positions in different proceedings depending on the federal agency against which they are litigating, the foundation argued, adding that the trial court may find those breaches of the settlement agreement, quote, material in ruling on any privilege, which I agree. So basically, they use campaign funds, and they're supposed to label it as campaign research. I can't remember the term right now, but they filed it under legal fees, which is two totally different things. Because if it was a legal thing, they can't no one subpoena. But they didn't fight against that when the FEC called them out on that. So it's not attorney-client privilege. You have no attorney-client privilege there because you said yourself, by settling, you basically admitting that this was not this was campaign, this was research, this was opposition research. That's the word I'm looking for. You basically admitting that this was opposition research. So that does not fall under the attorney-client peer review. But while the special counsel office made no mention of the FEC's findings in its response to the DNC and the Clinton campaign filings, the foundation's letter to Durham highlighted a second point that now proves precedent. In his letter, Backer noted that although the FEC memoranda, quote, will not be made public for another week, the details uncovered in the FEC investigation will likely be useful to the special counsel in attempting to counter the claims of attorney-client privilege pushed in the Sussman litigation, which I totally agree with. Indeed, the FEC memorandum released last week provided additional evidence countering the DNC and the Clinton campaign claims. Um, sorry about that. The campaign claims that the claims of privilege is not previously highlighted in the counsel's briefings. So this is very interesting. For instance, the Clinton campaign reported payments of 175 to Perkins Coie, 175,000 to Perkins Coie as payment for quote legal services, but the FEC memorandum stressed that Perkins Coie invoices did not treat all of the charges as related to legal services. Rather, the invoices reviewed by the FEC showed that in the billing, the Clinton campaign, Perkins Coie, distinguished between the fees for legal services rendered and the fees for professional services, other. The only services billed as legal services rendered, the FEC noted, related to the $5,000 monthly retainer fee paid to Perkins Coie. Conversely, all of the charges related to Fusion GPS's work charges appeared as professional services or other. So I mean, you got it right there. They got it in writing basically that this does not fall under attorney-client privilege at all. But the FEC memorandum also stressed that the invoices Fusion GPS sent to Perkins Coie for services rendered on behalf of the Clinton campaign listed, quote, a monthly retainer fee plus additional fees labeled as Russia research or Russian language research. Those Fusion GPS charges included payments, quote, Fusion made to its sub-vendor, Nellie Orr, which her husband worked for the FBI, conflict of interest there, Graham Stack, Edward Austin Limited, and Orbis Business Intelligence Limited. The sub-vendors all conducted opposition research for Fusion GPS related to Trump, the FEC memorandum explained. Again, countering the proposition that the subcontractor and its vendor were assisting Perkins Coie in providing legal services to the Clinton campaign. Similarly, the FEC memorandum discussed the charge against DNC, noted that it reported paying Perkins Coie $66,500 on August 16, 2016 for, quote, research consultant, while later invoices categorized the payment to Perkins Coie as fees for, quote, legal and compliance consulting. The FEC found the initial category of research consulting captured the accurate purpose of the expenditures and indicated the DNC realized, quote, research consulting represented the more appropriate classification of the expenses. So they even admit that it was basically consulting. Nothing legal, it was just research. So that doesn't, again, fall under the attorney-client privilege peer review. But the invoices also showed that Perkins Coie charged the DNC for the entire portion of the fees invoiced by Fusion GPS. This fact suggests Perkins Coie served as simply a pass-through entity for Fusion GPS opposition research. I've been saying that since this whole thing came out years ago, that basically they gave the money to the lawyers and the lawyers paid Fusion GPS. This concerned the commissioners, as a transcript of the hearing made clear. Merely running bills through a law firm could not convert them into legal expenses, the commissioners stressed. While the FEC analysis of the payment to Fusion GPS focused on whether the DNC and the Clinton Foundation properly reported the purpose of the expenses and not on whether the attorney-client relationship existed for purposes of privilege, the evidence discussed provides the special counsel additional ammunition to argue in support of an in-camera review of the documents and their eventual disclosure to prosecutors, which I hope these documents will be handed over to the prosecutors. But no matter how the court resolves the issue of attorney-client privilege, though the FEC's memoranda exposed the Clinton campaign and the DNC's attempt to hide their funding of the Russian collusion hoax, when the Sussman trial begins later this month, the country will learn even more details of the breadth and depth of the conspiracy when those behind the Alpha Bank hoax testify with or without the 38 documents now in dispute. And you know I'm going to be covering this. I'm going to be all over this. But let me know what you think. Leave your comments down below. Like, share, and subscribe. And check out demarcopublics.com for the latest in news. Until next time, peace.